Thank you for joining us this evening. The webinar will be starting in 5 minutes. Good evening. I would like to first start off this webinar by thanking you for sharing your time with me. Tonight's webinar is titled Wills, Trust, and Financial Planning and is an overview of the estate planning process. I am your host and presenter for this evening. My name is Myra Kasuk, and I currently hold the position of Financial Education Coordinator here at LAPFCU. Now, I'm looking here online. I just want to make sure that everyone can hear me. I do see some familiar names. As always, please allow me to remind you that tonight's presentation is scheduled to go for 1 hour and is being recorded. That time frame does include the introduction as well as questions that I will ask if you have at the end of tonight's presentation. If this is your first time attending a webinar, please allow me to draw your attention to the toolbar that was launched when you opened the link. Take a moment to locate your name. Next to it, you should see an icon that resembles a hand. If you can go ahead and click on that for me. Okay. Okay, great. That lets me know that you can hear me clearly, and I'll just either you can click on your hand yourself again to lower your hand, or I can go ahead and click on that icon and just lower it for you. In the essence of time, I will open it up for questions at the conclusion of tonight's presentation. Before I get started, I must disclose that this presentation is for information purposes only and is not intended to provide specific legal or tax advice. For specific legal or tax advice, please consult with an attorney and/or an accountant. Non-deposit investment products available through Members Trust Company are not deposits of or guaranteed by the trust company. A credit union or credit union affiliate are not insured or guaranteed by the NCUA, FDIC, or any other governmental agency, and are subject to investment risk, including possible loss of the principal amount involved. Members Trust Company is a federal thrift chartered under the Office of the Comptroller of the Currency, and it's also known as the OCC. Please also keep in mind that I am not a lawyer or a CPA. Those of you that do have a specific question that is not covered in the presentation are welcome to contact one of our Wills and Trust coordinators or licensed financial advisors. I will put a slide up at the conclusion of tonight's presentation with their information. We do ask our members what products they were interested in. So a lot of why we have this presentation, and we tend to have a very high enrollment and interest for this, is because we generally do ask what products and services our members are interested in, and the number one response continues to be wills and trust. With that said, in simple English, again, I'm not a lawyer or tax consultant, but with that said, I just do want to talk to you a little bit about how we came to be partnered with Members Trust. We contracted with them in 2008. They do offer investment management, estate planning, trustee services, as well as state settlement and attorney referrals, as well as federal charter by the OCC, and they have assets under management close to $2 billion. It is important that we provide these services to you as our members based on the nature of your work. So speaking on the nature of the work that you do, we all know that a crisis or a need for support can occur at any time. Yet most of us tend to not be prepared for such an event when it does happen. So take example, incapacity. Incapacity describes a condition in which you are legally unable to make your own decisions. I talk about planning for incapacity first only because incapacity, as it's stated, could occur to anyone at any time. So if you think for a moment what might happen if, for example, you were, let's say you were to become a victim of an accident that puts you into a coma for several months. If you ask yourself the following question, how would your doctor know what medical treatments you would want or not want if you can't speak for yourself? How would your personal business be transacted if no one was authorized to sign documents on your behalf? So I'll basically state this, that failing to plan means a court would have to appoint a guardian. Usually that could be a spouse, your child, or a close family member. That person would have to go to court and get legal permission to do things for you, and they would have to go back to court every time permission is needed, which could increase the burden of that guardian. Lastly, without any prepared instructions from you, your guardian might make decisions that you don't necessarily agree with. By taking steps to conduct estate planning, you are taking control of how you wish your affairs to be handled. Many people avoid this topic because it involves mortality. It's a little bit of it is discomfort to be able to talk to someone about your death, and a lot of times people don't like to talk about that. But it is that little bit of discomfort can go a long way in ensuring that your wishes are followed. Please remember that estate planning is more than just a will. It is used to address life's unforeseen events. And keep in mind, this is your legacy, and you should have some say in the monies that you leave behind. Taking the time to plan is a sign that you actually care about what happens to your legacy. And as I stated before, that alone is worth the initial discomfort about having these types of conversations. So, who receives your assets? So, first of all, take a look at the slide that you have in front of you. Did you know that without a will, the government decides who gets your assets? So, for example, state law may dictate that your assets go to a person who you would never choose to receive them. It won't matter whether or not they have the experience to manage inheritance wisely, or even if they have the knowledge to know what to do. When you set up a will, you choose whether it goes to your spouse, your children, grandchildren, friends. You can even select it to go to a charity. Your executor must follow your wishes. And there is no misunderstanding or imbalance on how your assets are distributed. So if you take a look at the very bottom of your screen, it says with intestate, it's the government's choice. Intestate is defined as dying without a will, and that basically means that it's going to be the government that will decide then what happens to those funds. Assets under an intestate are distributed pursuant to state laws to your spouse first and then your descendants. So why would you even need a will? Well, a will is a legal document, first off, that lets you spell out who receives your assets. It also states how those assets will pass, whether it is outright or in a trust, and when your heirs will receive them. So basically what that means in just plain, simple English is, do you want the assets to pass immediately or via a trust? And so let me explain by showing you an example. Okay, so this is another example why you need a will and what a will allows you to do. In your will, you name the beneficiaries that you wish to receive your assets. You generally can name anyone you want. This distribution might be outright, or again, you might determine that you want the assets held in a trust for the beneficiaries. For example, you may not want a minor child to have direct access to the assets until they reach a certain age. So say, for example, maybe 25 years old. You also have the opportunity to choose who the executor will be, whether an individual or a corporation like Members Trust Company, who I will refer to just in the essence of time, is MTC moving forward in this presentation. If you have minor children and you and your spouse pass in a common accident, you have the opportunity to name the guardian of your minor children. And that's not just for the benefit of managing their assets, but also for their well-being. Courts usually, they may follow the directions for guardians named in wills for minor children. So they usually follow those directions. Finally, if your children are minors or have other problems, such as being physically disabled, or they are spendthrifts, and spendthrift is just another word for saying an adult who spends money irresponsibly, you can set up what is called a testamentary trust. And this is a trust that goes into effect upon an individual's death, but doesn't allow the beneficiary to receive the assets until a specified time frame. Okay, what that basically means is that it dictates where the assets are held in trust for the benefit of that child, so the funds are not diminished inappropriately. Now, when the minor or spendthrift asks for the money, so say, for example, you have a child who is an adult but basically doesn't have very good spending habits, and you set up this trust for them. Let's say upon something happening to you, and you have a guardian that's looking over those funds, that spendthrift says, I need $140,000 for a Tesla that they must have in order for them to go to college. Well, the guardian can, take a look at the funds and say, you know what, you may only need $40,000 and get you a Honda Civic. That can do the same thing and still get you to and from school, so that they're not overly spending their money or spending it irresponsibly. As a parent of small children myself, I do like the fact that I can assist them financially, even in an untimely event were to take me away from them. So it's just something to think about. Just like trusts are revocable, you do have the ability to change your will using what is called a codicil. And that's basically a word that just simply means an update to your will. With a will, heirs have no interest in the estate until you actually pass. And that's when the will becomes irrevocable. But up until that point, it is revocable. Separate dispositions for tangible personal property simply means that you can divide it as you wish, either equally or unequally to your heirs. And like I stated earlier, a codicil is an update or an amendment to the will. As a reminder, if you pass without a will, the state will appoint an individual to manage the probate pursuant to those state laws. The choice is no longer yours to make. So it's extremely important. The most popular reason for using a will is to avoid probate. Probate is the court-supervised process of proving and administering a will. It is often time-consuming and expensive, depending on how large and how complex your estate is. At this time, I would like to ask you by a show of hands, who is familiar with the artist formerly known as? And just go ahead and click on the hand icon. Okay. How many of you, and I'm just going to go ahead and lower your hands, how many of you know he passed without a will? Okay, so yeah, the music icon passed away in 2016. And as of April of 2018, according to Forbes, his heirs have yet to receive 1 penny of his $200 million estate. The executor of his estate is unable to divide the monies among his 6 surviving siblings until the IRS and the executor agrees on the value of the estate when he passed. Now, as I stated earlier, the very first two bullet points say that probate is time-consuming and expensive. According again to the April 2018 article in Forbes, the executor and lawyers have already collected $5.9 million in fees and expenses. And this does not include fees for other lawyers that were used, consultants, or any advisors. Going through probate requires you to have an attorney, also known as a marshal, and as a result, your estate is subject to fees for the attorney and the executor. On a positive note, however, the good aspect of having a probate is that the estate is under court supervision. And what that basically means is it's subject to a limited time frame for creditors to make claims against your estate. So normally that time frame is anywhere between 6 months to 2 years. I bring up this example just to provide a picture to you on how probate can be time-consuming and expensive. And this is coming from someone that died with a ton of money, okay? So once the probate process is completed and the estate is closed, no other claims may be made against that estate property. I have checked. I do not see an update to that scenario, but again, this was just in April of 2018, and that's already been 2 years, and the monies have not been paid out yet. A living trust is a type of trust created during a person's lifetime. So it's designed to allow for the easy transfer of trust creator or settler's assets while bypassing the often complex and expensive legal process of probate. So when do you need a trust? We just got finished talking about like wills, and if you don't have a will, it'll go into probate. So when would a person need a trust? A good rule of thumb is if you have a net worth of at least $100,000 and a substantial amount of real estate or specific instructions on how and when you want your estate to be distributed, then a trust might be for you. I'm going to say that again just because a lot of times people, again, they don't get the difference between the two. If you have a net worth of $100,000 at least and a substantial amount of real estate, then a trust might be for use. And any type of specific instructions on how and when your estate is to be distributed, a trust may be something that you would like to think about. And I'll give you contact information for that as we get further on into tonight's presentation. A living trust is a legal agreement that is revocable. So when I say revocable, and I put that out there, and you know, my husband and I would talk about this a lot, that let's say you have a child and your dream has always been for your child to go to USC, and that child chooses to go to UCLA. You can remove them from your trust. I'm just kidding, but I do use that example with my husband a lot, but I'm seriously kidding. I'm not kidding, but I am. But seriously, it is a legal agreement that is very flexible. You can set up your living trust, and let's say you forgot to add an asset, okay? So again, as it being a legal document that's very flexible, you forget to add an asset and you pass away. You can also set it up with something called a pour-over will. That simply states that any of your assets that were not placed into the living trust will go there when you die. The living trust is private. However, despite its many attractions, and no matter what you may or may not have read, a living trust cannot completely replace the need for you to have a will. This is because it's very difficult for you to transfer all of your property to a trust. And any assets that you miss will be distributed under that state intestacy law that we talked about earlier. So remember I said if you die without having a will, it's going to be the government's choice. If you set up a trust and you do not set up a will, anything that you forget to put into that trust will then become that property of intestate for them to decide where it goes. So it doesn't replace a will, but if you have $100,000 worth of assets and you have some specifics that you like to put in the trust, you can still do that. And then in your will, you can keep it more on the general lines. I'd like this, this to go over to this family member or that family member. So it's a little bit different, but it does kind of save you in an instance if you were to forget to put some things into your trust, if that makes sense. The parties of a living trust include the grantor, the trustee, successor trustee, as well as the beneficiaries. Now, the grantor is the person who made the document. The trustee is the individual or corporation that will administer the terms of the trust. And that basically means that the grantor and trustee can be the same person. So I could be the person who created the document, and I'm also the person that is administering the terms. So they could be the same person. The successor trustee is the backup to the original trustee. So if something were to happen to me, I can state that the successor trustee is my husband, or I can designate someone else to be the successor, but it is the backup person to the original trustee. And of course, the beneficiaries are those that will benefit from the assets. And this could also be an unnamed class of individuals. Okay, and what I mean by that when I say it can be an unnamed class of individuals, such as I can set up a trust and then just basically put something like my then living grandchildren upon the death of my child, so that if as I get older, if I state that I would like my beneficiaries to be my grandchildren, and right now my children do not have kids, and I'm protecting them for the future in the event that I wasn't able to change anything before my untimely death, I can just put my then living grandchildren upon the death of my child, and that will cover them as well. Pretty simple. The grantor or donor is the person who creates the trust, and this is the maker of the documents. And again, as I stated before, the beneficiaries are those that are benefiting from the assets that are left behind. Creating a trust is actually a lot easier than people think it is, and anyone can do it. However, the biggest mistake that members we have seen have made is by failing to assign their assets to the trust. This is as simple as changing the title on your savings account or brokerage accounts by naming the MTC, which again I stated was Members Trust Company, as trustee of the John Q. Members Trust. That's just an example. Failing to assign assets to the trust is the biggest mistake members make, because without assigning assets and funding the trust, your trust is worthless. You did everything for nothing. So that's the biggest thing to remember. So just remember to retitle your assets in the trust name. Again, if you have accounts and money is in those accounts, you just want to remember to assign it under the trust name, and we can definitely help you with that. It is very important to complete this process. Without it, your assets, again, will pass to intestate. I can't say that enough. And it will be pursuant to the laws of the state that you live in. The benefits of having a living trust is that you can change it at any time. A very cool provision: as long as you are alive and not incapacitated, you have the right to change or revoke your trust at any time. You are only locked into the provisions of the trust once it becomes irrevocable. Again, another benefit of a living trust is that it avoids probate, as I went over with that example with the artist formerly known as. He had a lot of money and still going through a very timely and expensive process. We previously discussed this, but assets in a living trust are private and not included in your probate estate. It's also good to have a living trust because it's a backup plan. As I stated earlier, you can also designate a successor trustee to care not only for your assets during the remainder if something were to happen to you, but also your guardian of your property and personal well-being. You could set it up for that as well. And it also protects your heirs. So since you can change or revoke the trust, which does hold your assets, you have complete control over those assets during your lifetime, so long as you are not otherwise incapacitated. And we'll talk a little bit more about that later on in tonight's webinar. With a revocable living trust, you never lose control of those assets. So that's also a very good benefit. So if you're questioning, is a living trust for you, Members Trust Company, also known as MTC, nor the credit union, nor I can prepare an estate plan for you. You must retain an independent attorney to prepare your estate planning documents. You may use an attorney of your choice if you currently have one who has expertise in trust and estate planning, or we can refer you to 3 attorneys in your area that are capable of providing you with a viable estate plan. Attorneys do charge a fee for preparing a document. However, if MTC is named to act on your behalf and manage your trust, they charge a competitive fee. If you act as your own trustee, you may trade, buy, or sell assets of the trust also at any time. You will notice, however, in this presentation, I will not discuss taxes. First of all, each one of your situations will be unique. But if you do have a tax concern, I do ask that you please discuss that with a licensed tax advisor. Now, I did state that you can have a trustee of your trust, and a lot of times people want to know who should serve as the trustee, who should they choose. Now, although a family member or trusted friend can serve as a trustee, you do run the risk of creating dissension in the family. We've either all seen it before or heard of the family members that start arguing at a funeral when discussing financials that can arise after a person's untimely death. You also run the risk of having someone in charge that does not have the knowledge that it takes or even understands the process or the legalities surrounding it as well. The benefit of Members Trust handling this is they are a neutral party, and they also are objective with all family members. They are a professional team comprised of attorneys and CFA charter holders with experience. The other thing is that they have the capacity to be there for generations to come, and they are regulated by the OCC. So those are some benefits on having a company actually do that for you versus choosing a family member or a good friend, which you have the ability to do. We just want to make sure that you know all of your options. A person designated as the power of attorney, also known as POA, you'll hear that term a lot, has the power to handle your affairs. A durable power of attorney, however, stays in effect even if you become incapacitated and cannot handle matters on your own. It is, I do need to bring this to your attention, though, to be careful if you name somebody as a durable POA. The reason why is because you're granting someone durable power of attorney, and while that's in effect, that person has the power to handle all of your affairs on your behalf. If that's not what you wanted, you might try using a limited power of attorney instead. This provides them with limitations. But if you had someone right now that you have deemed as durable power of attorney, they can make decisions for you right now on all of your affairs. And so if that's not what you really had in mind, You can set that up as a limited power of attorney, or you do have another option, and that is having them be a springing POA. What a springing POA is it doesn't spring into effect until after a certain occurrence has taken place. That just basically means that you keep control until an event takes place that lets that power of attorney spring into effect. So, for example, I have a family member that was diagnosed with dementia. And because I know that this person has dementia, I can set it up to, or that person could set it up so that when they start losing a good portion of their memory, then that's when the power of attorney springs into effect, but not until then. And that is how they would have someone manage their affairs until they pass. We covered some other uses for a trust earlier in tonight's presentation. I talked about spendthrifts, and those were simply adults that were irresponsible with their finances. I went over the story about the Honda versus the Tesla story. Another reason for setting up a trust is for blended families. So if I have anyone on the line that is divorced, or you have a child from another relationship, you might be able to relate to this. The best example that I can give to this that probably a lot of people could relate to is the story of Cinderella. Okay, we've all heard the fairy tale of Cinderella. You know the story. It's about the girl whose father died and left her with an evil stepmother and 2 stepsisters. Well, setting up a trust is another way to ensure that your child from a blended family receives certain inheritance after your death. Lastly, another common use for setting up a trust is to provide those that may have special needs with specific care after a parent dies. These become more important in the case of families that want to ensure certain parties receive certain inheritances. Again, whether it's special needs, where you want to make sure that they have the care that they need, or again, if something were to happen to you and your family is blended and you have a child that you want to protect that doesn't have the same mother or father as the other kids in the family, you may want to think about setting up a trust for them as well. A living trust also speaks for you when you are unable to do it for yourself. It lets you determine the kind of medical care you want and whether or not you want extraordinary medical measures to be taken. It is important to be detailed so that the medical provider can understand exactly what you want. I can tell you that I do not wish to be hooked up to wires and lifelines in the event of my untimely death, or if I'm brain dead. I know that I have family members that would never want to pull the plug on me. But by being specific in what my wishes are, I can save them the trouble of having to do that. And of course, we covered durable power of attorney earlier. Remember that they do have the ability to make all the decisions on your behalf. So if it is something that you want, make sure that you trust the person that you decide to go that route with. I do see some questions coming in. I will address those at the end of the presentation, just in the essence of time to make sure that I cover all of the information, and also because your question might be answered within the presentation itself. Once you have an estate plan in place, the best way to keep it up to date is to review it regularly. Here are some everyday personal and family changes that may signal the need for an estate plan review or possible revisions of your plan. So, births and deaths in the family. Okay, you want to make sure that you update your plan. If a new addition has been made, you want to make sure that you add them to your estate. And if someone passes away, you want to make sure that you remove them from your estate. Marriage and divorces, there's nothing worse than wondering why the ex-husband or ex-wife has been called into your estate meeting, only to find out that your deceased spouse never updated their estate, and now everything was left to the ex. And if you're wondering if that really happens, yes, it does. So that's another example on why you want to make sure that you review it regularly. Another reason is moving out of state. Different states have different laws. So, for example, there are 16 common law marriage states. California, believe it or not, is not one of them. And each has specific stipulations as to what relationships are included. So many might assume that they do not need to include their spouse because they think that they're in a common law state, or maybe they were in one state and now they're in another. So you definitely want to make sure that you review it if you're moving out of state as well. Changes in the makeup of your estate, business changes, and of course also tax law changes. Remember, I'm not a CPA or a lawyer, so if you have any questions regarding tax issues or tax concerns, please talk to a licensed tax advisor on how your taxes may or may not be affected with any changes. As stated earlier, attorneys usually provide an estate packet including a will, trust, power of attorney, as well as durable power of attorney for health care. Cost is generally anywhere between $1,000 to $2,500 and up, depending on the complexity. We here at the credit union have vetted the attorneys in our program. So just simply let them know that you are a member of LAPFCU to receive special pricing. For more information, you can contact either George Regalato. He's based out of the Amazon Recruiting Training Center near LAX, or Beatrice Calindo. She rotates between our Santa Clarita, Van Nuys, as well as the LAX location and Regent Park. And they can be contacted at 1-877-MY-LAPFCU. That's 1-877-695-2732. I'll go ahead and repeat that in case you're writing it down. If you do miss it, however, I will have it up at the end of tonight's presentation again. Again, their phone numbers are 1-877-MY-LAPFCU. That, again, is 1-877-695-2732. Another thing that goes hand in hand with estate planning is financial management. We at the credit union also offer exclusive access to professional financial advice and investment services through CUSO Financial Services LP. We have 2 licensed in-house financial advisors. One is Chris Ellis. He's based out of our Academy branch in Elysian Park. That's right across from Dodger Stadium. And we also have, he also assists with the Los Angeles area. We also have Miles Lester. He is based out of the Van Nuys corporate office and also covers not only the San Fernando Valley, but Santa Clarita area as well. With that being said, both are extremely flexible and they do work together to assist our members with their long and short-term financial planning needs, regardless of the location. So you're in good hands either way. I also will have their phone numbers up at the end of tonight's presentation as well. So if you don't have enough time to find a pen, or if you feel I didn't stay on the slide long enough, it will come up again. In addition to that, as I stated earlier, this is being recorded and you will receive the link, which will give you the ability to pause the presentation at your leisure and to be able to take notes if you feel that there's something you wanted to go back and listen to. Before I go into some of the basics of financial planning, I must inform you that non-deposit investment products and services are offered through CUSO Financial Services LP, also known as CFS. They are a registered broker-dealer, member FINRA, SIPC, and SEC registered investment advisor. Products offered through CFS and not NCUA, NCU, SIF, or otherwise federally insured, are not guarantees or obligations of the credit union and may involve investment risk, including possible loss of principal. Investment representatives are registered through CFS. Los Angeles Police Federal Credit Union has contracted with CFS to make non-deposit investment products and services available to credit union members. Basically, what that's saying in plain simple English is that anytime that you invest in anything, you risk the possibility of loss of principal, and we just need to make sure, as well as all financial institutions, need to make sure that you are aware of that. With that being said, I will go into a little bit more about what a need for financial planning assistance does cover. Here at the credit union, we do have a lot of educational tools to assist you with budgeting and finances, and CUSO financial advisors have expertise in the following: financial planning for retirement, tax-efficient investing, 529 college savings plans, as well as help managing your investments in any financial market, best practices for retirement, and of course, estate planning. Each of you do have different goals for your future, and again, Chris Ellis as well as Miles Lester are available for complimentary financial planning. The slide that you're looking at now shows how your investments are allocated based on your financial goals. The left side, which is the blue side, is a description of each bucket. For example, you'll notice that at the very top half, it says short term, which means anything that requires you to have immediate cash flow or emergency funds. While the right side, which is your green side, provides your investment classification. So for example, if we need an immediate cash flow, where can we pull from? And with this, you can see that we can get that immediate cash flow from either having cash on hand, certificate of deposits, also known as CDs, money markets, short-term bonds, etc. If we skip down to the long-term bucket, you will notice that we start thinking about inflation and longevity. We need our money to last, and this is where we may consider growth stocks. We'll also start looking at real estate and other types of commodities. I want to make sure I see someone noted that they lost audio. Can everyone hear me? If you can, please go ahead and click on the hand icon. Okay, thank you. The biggest challenge faced by investors today is fear. So an example of that is when the Dow falls 1,200 points, do I get out of the market or stay invested? Now, because things can change rapidly, volatility tends to drive fear. This is becoming normal for the market, and it's something that we have to make sure that we don't overreact to, because it's easy for you to want to pull out when you see points start to fall, okay? Bonds, they have been bad. However, hopefully they will get better, but they still serve as a buffer for the losses if the market goes down considerably. Stocks are more of a risk versus reward type of item. Stocks have outperformed inflation historically and is where the rich tend to put their money. Other options that you have for navigating the stormy seas are international. However, this is the most complex area to invest in, and that's typically because of the difference in currency. Whether it's taxes or tariffs, and again, I don't really talk about taxes in detail, but just a general example with that. One of the reasons why it has the most risk for investments is because of the type of portfolio that it is. But in times like today, it can also be a very attractive allocation. A good example of this is when the U.S. dollar goes up, international funds tend to go down, and that's because it will take more international funds to add up to the amount of what the U.S. dollar is worth. The opposite side of that is if the U.S. dollar goes down, international funds will go up. And this is true is it true across the board? No, but diversification is key to any portfolio. If you want to understand more on diversification and how to take advantage of the different markets, please set an appointment with one of the financial advisors. Again, I will be putting their phone numbers up a little bit later. They will be happy to walk you through what is happening in today's market and to help you to understand, and give you a very complete breakdown so that you walk away feeling knowledgeable and that you can make an informed decision. Another key to navigating in stormy seas is to not make any sudden changes to your long-term investment success. Missing even a few days of the market's best days can hurt you. The numbers on this slide are a simple example. It's an old example, but it still helps to get the point across in what it means to take your money out, especially when we get scared. Let's say you invested $10,000 in the Dow in 2000, and you left it in there through May of 2016. You would have an annualized return averaged at 5.73% per year. But if you got scared and sold off during a market downturn and waited for stability to come back to the market and got back in, you would have missed possibly one of the best days on the market. If you missed 10 of those really good return days, you could have only averaged 1.18% for each year during that 16-year period. Like I said, the slide just shows us how having a plan and sticking to it with the diversified portfolio can help us achieve the best returns over a given time period. Both Chris Ellis and Miles Lester can give you some very good examples on that and can help you understand that in greater detail. Although the main portion of tonight's webinar is geared towards wills and trust, allow me to leave you with some retirement best practice tools. Again, and I stress this a lot, and one of the reasons why I stress this a lot is because I don't want any of you to walk away without talking to a CPA or a tax attorney if you have specific questions regarding taxes, because unfortunately, I am not able to answer those questions, but directly following this slide, I will leave the contact information to our licensed CUSO financial advisors that do work with LAPFCU. It is important for you to know when and how you will get paid and stay up to date with changes regarding your retirement. Ask yourself, do you have options for a beneficiary? How do you roll over your retirement? Who can help you to sort out your options? Okay, and in those events, we will point you to your consultants here at LAPFCU. Again, we do have licensed financial advisors that are free, okay? Their consultation is free. However, if you choose to work with CUSO, you are subject to an investment fee, and you will need to talk to them because it does vary based on how complex your situation is. As stated earlier, Christopher Ellis is based out of Elysian Park near Dodger Stadium and also serves the Los Angeles area, while Miles Lester is based out of our Van Nuys corporate office and serves the Valley as well as Santa Clarita. I will now open it up for general questions. If you have a question, please click on the question mark and type in your question. I will attempt to answer as many questions as I can before our time is up for this evening. In the event your question was not answered or you have a specific question, please contact one of the individuals located on your screen. And if you notice, I also listed the information if you have a question regarding wills and trust. If you would rather contact me, you can also contact me. My email is also located on the screen in front of you at mkasuk@lapfcu.org, and I will get your question to the right party. Okay, so a couple of questions are coming in now. Let's see, one question here. Does someone need to have a lot of money to have a will? And the answer to that is no. You can have a will with, you could have $10 and want to have a will. However, because inheritance may have certain tax implications, it is best for you to discuss those implications, if any, with a licensed tax professional. Okay. I have a question here. Will the link that you'll be sending out include the slides? Yes, it will. It will include the slides, not separately, but it will be a recording of the presentation. If you do want the paper copy of the presentation, you could send me an email. But again, I will be sending out the actual recorded version of this in a link to you, and you will be able to pause the slides at your leisure. The other thing I wanted to mention is that for the slides, you also will have access not only to view them when I send that out, you can also view an archived version of all of our webinars by accessing our homepage at LAPFCU.org. Hovering over services and resources and selecting archived webinars from the list displayed. And that will have a complete library of all the webinars that we have recorded this year. Okay, let me go ahead and take that off. Okay. My next question is, you mentioned a living will, but I didn't hear anything about a last will. Are they the same? That's a good question. A living will can be used to provide instructions, like the example I used for someone that is on life support. A last will, however, details how the assets will be divided after death. So I hope did that answer your question? Okay, thank you. Can a paralegal properly prepare a trust? You do need to go to an attorney in order to prepare a trust. I haven't heard of a paralegal actually preparing it, but you may have an attorney that may have a paralegal get the documents together. I would talk to a licensed attorney and see what they advise you on with that. Unfortunately, I'm not a licensed attorney, but I've only heard of attorneys being able to prepare a trust. At what age does the trustee have to be? That is a very good question. I know they need to be legal, but some say 18, some say 21. This kind of goes back to the slide that I showed earlier when I said who can you designate as a trustee, and it could be a spouse, it could be a family member, it could be a trusted friend. If they're of legal age, that's fine if you want to designate them as a trustee, but again, you are running the risk of someone not being knowledgeable to handle that. So we advise you to, talk to someone that is knowledgeable about that, but it is completely up to you if you want to have someone that's 21 years old to handle your trust, to be the trustee and designate them as the trustee. Does that answer your question? Okay. Okay, question here. Can you contest the will of someone you don't know? If you don't have a will designated, if you didn't set up a will and it's the government's choice, it's going to go down to it being the government's choice. There's a lot of things that you could contest, whether or not they will adhere to it. I'm not at liberty to say, but if you don't have a will set in place, that's why we try to, inform you to make the best options right now why we do have the chance to say that we have a say in these things, because you don't want to leave it up to the court. I'm sure that with the example that I gave with the artist formerly known as, I'm sure that there are people that are contesting that now, and it's gone on for 2 years. And again, it could be very time consuming, as well as it's very expensive. So it's best to try to get a will in place before that happens, so you don't have to worry about putting your family members through that in the event of your untimely death. Okay, thank you. Okay, looks like I have time for about one more question. It says, let's see here, are there any other reasons people set up a trust for a spendthrift? What if they do not need a car? That's a good question. The car was simply an example, but to answer your question, yes, some people can set up because the beneficiary, maybe they have a lot of debt and they have a lot of creditors who are otherwise trying to collect their funds, so it's a good way for them to protect those funds. Also, you could be a parent that is concerned about a beneficiary that is an addict. There's a lot of different reasons. Maybe you want to protect them from spending all their cash to satisfy an addiction because they just are, spend happy. There are a lot of reasons that a person might want to set up a trust. In the end, it is simply to protect them from overspending or spending on unnecessary items. And again, some parents set it up because they do have creditors. Maybe their adult child owes a lot of people, and it's a way of also protecting those funds so it's not all divvied out to that person. I see that there are a lot of other questions coming in. What I will do is I will go through your questions and get you to the right person. If you're interested in that, I can definitely do that. As a reminder, this presentation is being recorded and will be sent to all members that registered within the next 2 business days. As I stated earlier, you can also view a list of all of our archived webinars by accessing our homepage at LAPFCU.org. You would simply hover over Services and Resources tab and select Archived Webinars from the list displayed. I would like to take this time now for thanking you for sharing your evening with me. I do look forward to seeing your name populate at future events. Have a good evening.